Essential of a valid contract of insurance. Essential of every contract. Under the Contract Act 1872, there are certain essential should be fulfilled when we do the contract of insurance. One, offer and acceptance, consideration, that is premium, competency of parties, section 11, pre-consent, section 13 to 19, lawful object and lawful consideration, section 23. And special essential of the insurance, say insurable insurance, utmost good faith, uberi mai fidei, principles of indemnity, proximate clause, causa proxima, doctrine of subrogation, doctrine of contribution. So what is offer and acceptance under the Contract Act 1872? There are two parties, one is the insured person, another is the insurer. So insured and insurer. So insured will give the proposal and the unconditional acceptance by the insurer. The insurer is the company which take the risk of the insured. So contract concluded when proposal is accepted and policy covers is not issued. Consideration premium. Premium is the price of the promise. A premium can be lump sum or periodical, suppose such as monthly, yearly, singly premium. Without premium, the contract is generally voided and unenforceable. Competency of parties, section 11. Both parties must be measure of sound mind and not disqualified by law. Company or insurer must be registered under the Insurance Act 1938. Pre-consent, section 13 to 19. Consent must be free from coercion, undue influence, fraud or misrepresentation or mistake. If consent is obtained by fraud or misrepresentation, contract is voidable. And case law is Mithulal Naik versus LIC, AR 1962, Supreme Court 814, policy provided for fraudulent misrepresentation by insured. Lawful object and lawful consideration, section 23. Object must not be fraudulent, illegal or opposed to public policy. Insurance used to cover the smuggling, abetting, etc. would be void. Special essential of the insurance contract is insurable insurance. Insurance means a legal and financial interest in the subject matter of insurance so that the insured benefits from its safety and suffer loss from its damage. When required, the life insurance and insurable interest must exist at the time of entering in the contract. When required, the insurable interest in case of the property fire insurance, the insurer interest must exist at the time of the contract and at the time of the loss. Purpose: to distinguish the insurance from the wager. Case law Makura versus Northern Insurance Assurance Company 1925 AC 619. Shareholder has no insurable interest in company's assets. And LIC versus Asagwell 2001 2 SCC 160 reiterated that the life policies required insurable interest at the inception. Utmost good faith, uberi mai fidei, insurance is a contract of utmost good faith. Both parties, insured and insurer, should disclose the material fact. So in case of insured should disclose the age, health, previous illness, other policies, hazardous occupation, prior fire claims, etc. Insurer should disclose the exclusions, waiting period, conditions and limitations. Case law LIC versus GM Channa Basamma 1991 1 SCC 357. Supreme Court simply held that the insurer must prove the deliberate suppressions of material facts to repudiate. Sant Satwant Kumar Satwant Kaur Sadhu versus New India Assurance 2009 8 SSC 316. Non-disclosure of serious kidney disease, breach of utmost good faith, claim rightly repudiate repudiated. Reliance Life Insurance Company versus Rekha Ben Rathod 2019 6 SCC 175 reaffirmed the strict duty of disclosure in proposal for principle of indemnity. Except life and personal accident, insurance is purely indemnity. Insured can recover only the actual amount of loss subject to policy limit. Prevents unjust enrichment. Section 124 to 125 Indian Contract Act Indemnity. Case law Castellian versus Preston 1883 11 QBD 380 Classic Rule. The contract of insurance is a contract of indemnity and indemnity only. United India Assurance Company Limited versus Kantikia Color Lab 2010 6 SCC 449 Supreme Court. Insured cannot claim more than actual assets loss even if some assured is hired. So there is a principles of indemnity is there. Proxima cause proxima. Liability depends on the nearest and effective cause, not on remote causes. If the proximate cause is an insured peril, insurer is liable. The Posse versus Scottish Union and National Insurance Company 1907 defined proximate cause as the active and efficient cause. New India Assurance Company versus the Pradeep Kumar 2097 SCC 787 Supreme Court applied the proximate cause in fire claim. Insurer liable while the fire was dominant cause. Doctrine of subrogation. After indemnifying the insured, insurer gets all rights of the insured against the third parties responsible for the loss. Operates automatically in indemnity contracts. Our case laws is the Economic Transport Organization versus Choron Spinning Mills Private Limited 2010 4 SCC 114 Supreme Court upheld the enforceability of subrogation. Subrogations come assignment and explain its nature. Doctrine of contributions. When some subject matter and same risks are insured with more than one insurer, all insurers must share the loss relatively. It prevents the insured from recovering the more than the one indemnity. Case laws North British and Mercantile Insurance Company versus London, Liverpool and Globe Insurance Company 1887 foundational English case. Bombay High Court, the New India Assurance Company versus Protection Manufacturer Private Limited year 196 Bombay 179 applied contribution between the fire insurer. Mitigations of loss. Insured must take the reasonable steps to minimize the loss when peril occurs. If insured is negligent or increases loss willfully, insurer can reduce or deny the claim. Case law open applied through the policy clauses. Courts treat the mitigation as part of good faith and reasonableness. Thank you.